Hello, my name is Rehbinder. Welcome to this presentation on personal data. In the European Union we have a general data protection regulation that defines personal data. Personal data means any information relating to an identified or identifiable natural person. So the definition of personal data is very wide. We also have definition of the processing. It means any operation or set of operations which is performed on personal data. So also the processing definition is very wide. So when you are processing something related to a person that can be identified, that is personal data processing according to the GDPR. GDPR has requirements for how personal data is used. Use must be transparent, lawful and fair. It must be collected for a specific purpose. There must be data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. Personal data legislation protects the rights of data subjects. Controller is accountable for the processing of personal data and also for those processors that the controller uses. There is a requirement to do data protection impact assessments to assess the risks to data subjects, and controller must mitigate the risks and limit the use of data to those uses that have legal basis. That is the lawfulness requirement. Privacy notice describes how personal data is used by the controller. That is the transparency requirement. If you are not transparent, then you are violating the GDPR. And for example, Google was fined for not being transparent in its use of personal data. Accountability means that a company using data not only needs to comply with the law, but also be able to show and have records of processing showing that it has been following the law. There has to be policies in place, procedures, there has to be legal basis for every kind of processing. You have to do the data protection impact assessments when there are risks to data subjects. You have to take privacy by design and default into account. So when you plan the use of data, plan it so that you minimize the use of data, so you don't collect unnecessary data. And if you can collect data anonymously and not use the names, then do that. And also try to differentiate between data at rest and what you need for searches. You have to define data retention times. You have to have employee training. As you said, you have to record how you have used the data, and you have to inform the data subjects with privacy notices. So before you start collecting the data, you must inform the data subjects of the legal basis and purposes, and they have to be informed in a concise and clear way. So in a typical privacy notice by a company, you would describe what kind of personal data the company collects, where it collects that data, how the company uses the data, what are the legal grounds for using personal data, is there automated decision making and profiling and explaining of this, data storing and security, sharing your personal data with other entities, the international transfers of data, customer rights and how they can assess their personal data, and who they should contact if they want more information or if they have requests concerning their data. Lawful basis is always needed for processing. Here are some examples of an insurance company, what legal basis they have used for their processing. So there are several legal bases in the GDPR, and consent is not the only one. There are several others, and consent is also not the primary. So if every legal basis is as important and as valuable and can be used if it fits the purpose. So processing can be necessary for conclusion or performance of a contract. There can be consent to process, for example, health data. This is a special category data. If you base the use of data on consent, then the data subject has to be able to withdraw that consent as easily as it was given. If you send customers direct marketing offers, then the legal basis for that can be legitimate interest, or is legitimate interest. And processing can be necessary for compliance with a legal obligation, like here for the motor insurance bureau. If you use profiling or automated decision making, you have to take into account that decision based solely on automated processing is actually not allowed except in some defined cases. It has to be, these include that it can be a performance of a contract between the data subject and controller, or authorized by union or member state law, or based on data subject's explicit consent. And the data subject always has the right to contest that automated decision, and also to obtain a human person to look at that decision. So the VP 29 has given more guidance on how this should be done. The automated decision making usually uses algorithms, and the data subject has right to receive meaningful information about the logic involved. It can be challenging to understand how an automated decision-making process or profiling works. Controllers should find simple ways to tell the data subject about the rationale behind or the criteria relied upon in reaching that decision. So there has to be meaningful information about the logic involved, but the disclosure of the algorithm is not required. Anonymization is another difficult objective to achieve. There's also guidelines on how to use anonymization techniques from the Working Party 29 that also gave that guidance on automated decision making. Working Party 29 consists of supervising authorities of EU member states. The name for it is now European Data Protection Board, and it gives guidelines on personal data use. So the guidelines given by previously Working Party 29 and now the European Data Protection Board are a very valuable authoritative source on how personal data should be processed. So look at these guidelines to find more information. The General Data Protection Regulation is the general legislation on privacy or personal data use. Then there are specific legislation. One across the Europe on directive is the e-privacy directive, which applies to the processing of personal data in public communication services and networks, and this is implemented international laws. There are requirements to collect users' informed consent to store cookies or to process location data, for example, location data of a mobile phone. So This directive is now under the process of drafting a regulation on privacy and electronic communications, so follow that closely. They are trying to make that regulation to work with the GDPR, but the legislation process has been quite long and difficult. In addition to the e-privacy directive and national legislation implementing that, for example, only in Finland there were over 600 specific legislation concerning use of personal data. So in any field also you have to check the specific legislation of that field in addition to the general data protection legislation. So this field is quite complex. We have also guidance on how to use personal data in Aalto University studies and research. Thank you.